Good morning. For a criminal trial or civil, whatever may be the trial, Evidence Act will play a vital role, and particularly Chapter 6 of Indian Evidence Act deals with the exclusion of oral evidence by documentary evidence. If documentary evidence and oral evidence are admissible, the court may go by the evidence which seems to be more reliable. That means documentary evidence. Best evidence, rule of best evidence based upon the documentary evidence. The main object of the law of evidence is to restrict investigation made by courts within the bounds prescribed by general convenience. So this must be confined to matter and issues. Hearsay evidence must not be admitted, and the best evidence must be given in all cases. So then that is commencing from section 91. Evidence of terms of contract, grants are reduced to document either by primary or secondary evidence. It should be proved. That is best evidence. Then exclusion of oral evidence. Section 92 says once any such contract, grant or deposition has been proved by the writing, then no evidence can be given by oral agreement to contract or change the terms of the contract. In other words, no oral evidence can be given to qualify terms of the document. Then they say evidence can be given of any fact which would be invalidate the document in question. Invalidate means by fraud, intimidation, illegality, failure of consideration, mistake of fact or law. For that you can give oral evidence to disprove the documentary evidence. See, ambiguous documents. If the document itself is ambiguous, it not make clear sense, then oral evidence may be allowed to clarify the language or remove the defect. Then question arises, the clarification should not be amending the document. Only to explain. So oral evidence should not be given that to amend the document. That means alter the contents of the document. When language used in the document is in plain itself, when it applies accurately to existing facts, evidence may not be given to show that it was not meant to apply such facts. Then according to 95, language of document is plain, but its application in existing facts meaningless. Evidence may be given to show how it is intended to apply these facts. Examples are given. You go through that. Section 96. If language which can apply to one only of 7 persons, oral evidence may be given. Then question arises, language of document applies partly to one set of facts, partly to another, but does not apply accurately to either. Evidence can be given to show which facts the document was meant to apply. According to the evidence may be given to show meaning of illegible or not commonly eligible character, foreign, obsolete, technical, local and provisional experts. Evidence by non-parties. Persons who are not parties to document or their representative in interest may give evidence by fact tending to show contemporaneous agreement verifying the terms of the document. So finally, section 100 says these provisions, chapter, shall not be taken to effect any of the provision of the Indian Succession Act 1865. Now that has been amended, replaced by Indian Succession Act 1865, which has been subsequently amended. So all these things you have to see if the document is plain, correct, eligible, legible, and substantiate the only one particular fact, so oral evidence need not be adduced. If suppose some lacunas are there, that can be clarified, not amended, clarified by the oral evidence. Then question arises, to disprove the execution, fraud, misrepresentation, no consideration, against fact, question of fact and law, you can give a oral evidence. Best wishes.